article would constitute a subordinate legislation.
There's no need of its publication. It's not under Article 304.
No,
Video to
the
Article
Apex
304.
Court said any subordinate legislation, how and when it becomes effective, publication or promulgation must be made in a gazette.
But where is the need of publication of an executive instruction in Gazette?
If it's an amendment to something which is in the nature of any notification of the government must be through the
But
gazette.
You're right, but the amendment is to page number 168. That is also
But it should be through a
that is
publication
also
in
an
the
executive
gazette.
instruction. That is also not
The
a-
reason is this. No, that may or may not be, but the problem is this. One of the pleadings that we have taken is that this was not in public domain for a long time. Anyway, let them continue their arguments. We'll deal.
Yes. We are only on the question of interim relief.
Yes.
Yes.
My lord, the two issues, my lord, which in fact raised my lord,
What is the nature of selection?
Group 1 selections. Group 1 selections.
Group 1.
Group 1.
Yes.
In the state cap. Well, a notification is issued on 19/2/2024 for 563 posts. my lord.
Anybody prepared any synopsis? Anybody prepared any?
I've been already last year itself.
See, synopsis. Any synopsis are there? It is heading a synopsis of WP 2603.
38, my lord. Your lordship wanted last occasion about the GO, earlier GO, and present GO, etc. That synopsis.
Yes, please.
Well, before that, my lord, just my lord, two issues.
Yes.
My lord, one is that, my lord, we are challenging, my lord, Rule 22, B, my lord, which is added through GMS number 96. My lord, stipulating the roster points to, my lord, in respect of the physically handicapped category. That, my lord, that rule is also challenged in this writ petition. That's the one issue. Second issue is, my lord, rule of reservation is not followed by issuing this GO. Amending earlier GO 55, your lordship notice. These are two issues which are consideration for your lordship, kind consideration. One is that physically handicapped quota, my lord, your lordship knows, Rajkumar Daria, every principle of law, it has to be horizontally. But the rule has been amended.
Yes.
Rule 22, your lordship will get it page 52.
That is at
150
page.
Page 152. GMS number 96. This is made under Article 309 of the Constitution of India.
Yes.
Well, at bottom, set rules in Rule 22 in sub-rule 2. Well, the following shall be substituted, namely out of 50 appointments to be made on the basis of the open competition. Well, that I am not worried about it. Well, next, page 153. B, clause E, proviso to following substituted. The 6th, 31st, 50th, 56th turn, each of 100 vacancies, roster point, shall be allotted to the blind, low and so and so, shall be allotted. Intellectually disability, so and so, learning disability, mental, so and so allotted. In terms of the GMS number, so and so 38. Once it is horizontal, question of giving the roster points will not arise. Lordship notes, once it is horizontal, the persons in the physically handicapped suppose with the meritorious. They will come up in the open. So this can't be roster points at all. And a notification, your lordship will get it. Page 4.1, notification, page 50.
Page
50.
50.
Yes, ma'am. 50. There will be reservations in direct recruitment in respect of scheduled tribes, scheduled castes, backward classes, and economically weaker sections. Persons with the disabilities, well, that is all shown as a vertical. And horizontal in respect of women and meritorious sports persons, so and so. When physically handicapped, Reservations also is special reservation.
But how you are bifurcating it by reading 4.1 that the horizontal, they have mentioned horizontal.
Horizontal only for in respect of women and meritorious.
Yes.
Vertical reservation, that is a community wise, you will get the first limb of the provision.
Yes.
This is against the principle of law decided by the Honorable Supreme Court. I'll take the judgment, Rajkumar Daria and subsequent judgments, which says it has to be followed horizontally, and horizontal reservation, your Lordship knows that. First open, then will not be reservations of social categories. Thereafter will not the rest of will be. Even that also will not, if a physical handicap comes, will not, he will be accommodated in the social categories only. After that, suppose any remain, that will go to the vertical about it, not will not this stage.
You are basically agreed about these handicapped persons, those who are not getting a reservation of their category.
What happened by giving the roster point, the 4% reservation, there are 24 posts have been earmarked for them. Merit people will come, physical handicapped people, merit they will come. But in the vertical reservation, they will be fixed at the roster points. Had the merit people have been taken into consideration in open category, I would get more seats available for me to compete. So my second argument, I'll explain further about it. If it is taken as a horizontal, the more seats will available for other categories. If the physically handicapped will fall under the open category.
Yes.
And not only that, second limb of it, if this 4% is taken, it violates the 50% rule in the state. I think Rahul will agree that 29%, 15%, 10%, if it's taken, suppose 4% is added, it will go to 54%. So if that goes beyond the 50% of the Balaji, Indrasani principle, etc. Therefore, keeping the physically handicapped in roster points is illegal. I'll place one or two judgments, but Lordship can find consideration after my second issue. And the second issue is concerned with regard to non-following the reservations. Issue is concerned with admission. Now the preliminary examination is held. Now the main examination, they have announced the website. In the website, what they have done is that 1:50 is the criteria as per the notification to call.
When main examination is scheduled?
21. 21 to 26.
All tickets were issued to the candidates.
Now the second issue is that admission to those main examination without following reservation category wise is violated of Article 14 and 16.
Yes.
Without categorizing. Social reservations and only taking the merit into consideration for the purpose of main is illegal, violated of Article 14 and 16 of the Constitution of India. And if they segregated, the SCBC category is open instead of open category. Here also the reserved candidates will have a number of more candidates will come. Now what they have done is 1:50. They have announced website 192 about Lordship kindly see page 192. On the basis of the preliminary test,
Yes.
Page 192. On the basis of the preliminary test of so-and-so on 9/6/2024 for the post falling in the group 1 service notified, the candidates with the following hall ticket numbers have been admitted to the written examination as per the criteria mentioned in the GOMS number 29, which is under challenge. I'll take that. That accordingly, this website, your Lordship will get a page 194, 31,000 some odd has been called. Your Lordship will get it page 194. 31,382.
Yes.
Your Lordship may come to GOS number incorporated here, but Your Lordship may can come to the GO itself.
That is at
178.
page.
178. This is in fact, this exam is the third time for the same post. In fact, earlier exam was conducted for the same group 1 services twice for 503 posts. For some reasons, once for the manipulation, second, not following the biometric system, this on-board code cancelled those things. And thereafter this notification is issued. Now they added another 60 more posts and issued notification. Just before the notification, this GO has been amended. GO 55 is amended. GO 55 you also will get it in 168. And those two notifications they followed GO was 55. 168 emissions.
Yes.
And come to the GO, relevant GO portion is concerned, page 171. Pattern of examination.
Yes. Yes.
There will be preliminary test for the comprising of so and so. Test is meant for the shortlisting of the number of candidates to be admitted in the written main examination. The mark secured in the preliminary test will not be counted. Ranking in the preliminary test will be counted in English so and so. B is relevant, which I am affected by that. The number of candidates to be admitted. The number of candidates to be admitted in the written main examination, conventional check would be 50 times to the total number of vacancies available each multi-zone. Duly, this sentence was supported. Duly following the rule of reservation, community-wise, gender-wise, posts laid down as per the general rule 22(2)(a) of TS state and subordinate service.
Yes, sorry, we'll assemble after 10 minutes.
Yes.
in 2023.
We are in 24.
Yes, Milord.
23 February.
But recently they called for grievances, Milord.
Notice for admission, GP services
Your
1.
Lordship, let them consider as per the grievance, Milord. In the morning, your Lordship passed an order.
No,
Similar.
there was no rejection. Here your appeal was rejected.
He has not challenged it, might be. Every order has been rejected, Milord. Every appeal has been rejected.
Let them file counter. We'll decide the legality of that. GP services
Let them
1 takes
consider, Milord,
notice.
there are vacancies, Milord. Now the government, Milord, considering the 2008 candidates.
Once
If they been considered and given appointments, Milord, in the vacancies, Milord, then he will suffer, Milord. Your
Milord,
Lordship,
once
kindly
you-
consider for interim direction.
My
Milord.
submission.
No interim direction.
Once you
Either
give-
disposal or
I
notice.
file a list of the vacancies, Milord.
Maybe.
A lot of.
That is for the government. They have to
Let them
ask.
consider, Milord.
Notice for
Interim
admission,
order only,
GP services
I'm
1
only
takes
asking to consider the
notice
grievance,
for
Milord, as per the
respondent
grievance.
6.
Verification also completed, your Lordship.
What do you say about the grievance?
Verification.
Milord,
Let
my
them
submi-
consider
my
grievance,
submission,
Milord,
right?
pending rectification.
Because he is also experiencing the other side, this side.
Like Satish case,
Not like that, right?
yes,
First time he made an application, it is pending before the online.
yes,
Then he will ask you to dispose the directive response.
correct.
Here they come forward and rejected the claim of the individual. It's
Same
an
as
improved
that.
order.
Rejected
Unless-
by government only.
Unless that is set aside by this court, a finding is given,
Yes.
then she has not made out of
Counter.
that case.
And again, they call for the grievance,
Natural.
Milord, this government.
8
Having
weeks.
issued orders.
Let them file counter.
Your Lordship post motion.
No, we'll see. Let them file
Lordship
counter.
posted.
4 weeks, 8 weeks for
8
counter.
weeks, Milord, your Lordship kindly see.
22 order. We are in. No.
23 they serve, Milord, because this government called for grievances.
We are posting in
Milord, they have
25.
not challenged.
23, 22 orders out in 23.
Since this
You-
government
you have filed
assured
it
them,
in
Milord, to
24.
solve the grievances.
We are
That is the
posting in
reason they
25.
couldn't approach. Having taken the grievances, Milord,
What is the
having
next case?
completed the verification,
What is the
they are
next
not
case?
considering.
Same.
Same.
Next also see.
I must say, notice for admission, GP services 1 takes notice. And 6 time to file counter. Post of 8
Give
weeks.
some date, Milord, otherwise it's not seen.
Yes, give a date.
10-11.
These type of cases, Milord, they must be.
Lordship.
These are all
8
admitted.
weeks.
10-11, your Lordship, 10-12 అంటే vacation వస్తుంది మళ్ళా January
10, 12, no. Vacation, ఇంకా 4 నెలలు ఉంది అక్కడ. Yes. Next. Yes, Narsim.
Bishop selected to post of secondary teacher purchase notification 98. Subsequently respond prepared senior list as per roster points.
No, what is under challenge?
Last week I.
Impugn action is not.
Judgment in OA number last week 2237 of 2009. They implemented in respect of all the prisoners except the prisoner on the ground that a prisoner not well contemplated.
Where is that order?
Last week I.
Show us the order.
Page number 48.
48 is 48 is proceedings dated 5/6/24.
Yes, no, but they implemented all the.
Show us the order, sir. Court order, tribunal order.
Yes, last page number 39. The last week NDC D. Kumar Swami. Second name prisoner in the present witness
Yes,
file.
yes.
Your last week NDC interim order.
Show us the order.
41. Page number 41.
Yes,
Pending
read.
for the promotion council to post of schoolmaster map to info shall be taken up by taking into account merit list and ranking assigned by applicants who participate here. The direction to prepare senior.
So where is the final order? This is only interim order.
Next to 43.
43, yes.
Page number 45.
Yes, GP.
Only on the ground that prisoner not find contempt only.
Page 39 order.
They implemented page number 48.
Get instructions, we will post next week. Both are same? Yes. But request to the government.
Only instructions.
It request the government bidder to get instructions. Post on 28th.
In the urgent motion.
In the urgent motion, is both. Yes. Yes, sir. Yes, GP. You are not received. Next week, at request of the government to get instructions. Or file your counter. We have already direction is there. We'll issue notice. What is the matter about?
Regarding certificate, they were not allowed to participate in certificate verification. Madam.
That will be directed. We are
Yes,
concerned.
that.
Then let them file counters.
Yes.
Notice for admission. GP services one takes notice and seeks time to file counter. Post after 8 weeks.
May I please?
Yes, sir.
The petitioner is seeking promotion to the post of joint at agriculture. Charge memo is of 2017, incident of 1516, and not enquiry of such charges not proved. They issued show cause notice on 8/4/2024, indicating disagreement factors. He submitted an explanation 8/5/2024. So it's more than 7 years have elapsed. I filed similar orders. It's
What
coming
happened
for,
there after 8 5?
no, last time lordships have directed the government to get instructions only on that.
Yes. Yes, madam. Page 69. Come to page 69.
61 to 68 is the show cause notice.
61 to
68. 69 is my explanation on 8/5/2024.
show cause notice dated 8/4/2024. You have filed on 8/5.
Yes. And charges are not proved. The issue of disagreement, it's more than 7 years now. Chamanlal Goyal in this case.
Where is the inquiry?
I filed along with the memo. Your lordship, kindly say disagreement factor. Page 61 itself it will indicate. Page
Yes.
61.
Yes, sir. Read.
Subject part of it.
Yes.
Charges frame so and so. Written defense may submitted, not convinced. Enquiry report submitted. Communicate reasons for disagreement. His allegation against him is lack of supervision. That has resulted in misappropriation. He did not misappropriate any amount.
Where is the charge memo?
Charge memo, page 19.
Is Hukya.
Yes.
For
Lord,
working.
you see the charge memo. Has failed to check the important facts in the records pertaining to so and so. And charge to negligence. And the person data entry operator, I filed his statement. He admitted, I have stolen the checks. The checks were in custody. I will not go into merits of the case. I have submitted my show cause notice. The
Yes.
checks.
Yes.
That is a notional promotion. That is a notional promotion. I made as a proper party. If you lordship look at the main prayer, at the relevant point of time, there is no proceedings pending against him. But juniors were promoted. And that is covered by lordship's order. Subsequent proceedings will not come in the way. But in interim prayer, I am seeing limited direction to consider without reference. It's more than 7 years now.
Correct.
Your lordships can say no final orders are passed till date, till today. That rider may be added.
We'll post on Monday. That request to the.
No, Monday
Come.
also, situation will be same on Monday also.
If they pass final order.
No, even if the lordships kindly see the prayer, that's the reason.
Yes.
main prayer, page 16.
Yes,
Because he was neither under suspension, no charge sheet, no charge of the relevant panel year.
yes.
And review DPC was conducted in 2019 for 16-17 panel. They ought to have considered in review DPC also. They did not consider. Then he made a representation. And the proceedings were being continued. It was more than 7 years. Chamanlal Goy will come, either way.
Yes, yes, that will consider. This is in Bhaskar's case, not this.
The inspector's case, the
No,
Lordships
no,
have
in
passed
one
a
case,
Your Lordships
Degal
have-
Suryanarayan relying
Yes,
on
sir.
Degal Suryanarayan.
Lordships have passed a detailed order. It's a final order.
Monday, as a last chance post on Monday, in the same list.
list. Much.
The same list, yes.
Your Lordship,
Yes.
this matter pertaining to the wages of multi-purpose workers at Gram Panchayati level, my Lordship. Last two occasions, they seek time to get
What is the
instruction. Issue is that, my Lordship, they given representation, my Lordship, on 25/6/2024, page number 52. Last occasion, I read this representation, my Lordship.
What is the issue, sir?
Issue the non-payment of wages to multi-purpose workers, my Lordship. These workers are
Read your prayer.
in representation, my Lordship.
To addressing the grievance of the petitioner with regard to their work conditions, wages,
Work conditions, wages,
security.
social security of multi-purpose workers in accordance with law and rules in force.
Let the file counter notice for admission. GP services to take notice and 6 time to file counter. Post of 8 weeks. Yes, next. What are your instructions? File your counter. Yes. 8 weeks. Yes, next.
Independence. We challenge the orders for the third respondent in refusing to admit the petitioner in the duties of the third respondent office and not paying the salaries from the work from 13 to 19. Because
Yes, notice for admission. GP services to takes notes for 1, 2, and 4. Mr. Speak Kishore takes notes for R3 and 6 time to file counter. Post of 8 weeks. Yes. For counter. Yes, notice for admission. Mr. D. You are taking notice. Mr. Anurag takes notice and DAG takes notice and 6 time to file counter. Post of 8 weeks. Yes, next. Yes, Deepika.
This is the service matter. The petitioner suffering with HBS AG positive. The petitioner is not providing the employment. But the similarly situated person appointed the employment. We have the order copy.
Yes, Singirani. Where is your representation?
Page 16.
1/6. This is fresh representation 15/9/2024. Yes, having come. Dispose of. Consider this page 16. Date. Huh? Which order copy has to be included? 55. Yes, yes. Yes, come. Having regard to submission made by respective parties without going to merits of the case, మీరు ఒక ఏం చేయాలంటే ఆల్రెడీ మేడ్ రిప్రజెంటేషన్ 15/9/2024. However, seeks permission to file fresh representation by enclosing the orders of this court in WP number 30997 of 2022 dated 14th September 2022. Having regard to the submission made by respective parties without going to merits of the case, petition is disposed of, directing the petitioner to make a fresh representation by enclosing relevant documents. On receipt of such representation, the response are directed to consider the same and pass appropriate orders in terms of the orders of this court in WP number 30997 of 2022, dated 14 September 2022. Either expedient as possible, preferably within a period of 6 weeks. Yes.
May it please. Last occasion posted for instruction of the corporation unit.
What is the matter about?
Matter is about providing dependent employment to the petitioner. Instead of the eligible candidate, the petitioner, the respondent corporation are proceeding with the dependent employment to the respondent number 4.
Who is R4?
Married daughter.
You are?
I am the son.
Sir.
As per the
What
rules
are your
in
instructions? Have you filed any application?
I have made a representation,
Where
page
is it?
20. Page 20. Because the petitioner is becoming aged out, your lordship,
Where is your representation?
Page 20, your lordship.
It is not representation, it is a legal notice.
On behalf of the petitioner, is a nothing but
You
a
want to make,
representation. It's on behalf of the petitioner, it was issued through his counsel, requesting the same grievance. So the petitioner, under the cap of 35 years to 40 years. Earlier, it, as per the circulars, the cutoff age was the 35 years. Now the present circular,
So you
the
want to make fresh representation or not?
if it is considered, my purpose will be served. Yes.
It won't be considered. We won't consider that letter. That is your legal notice. Yes. If you want to make application, we'll permit you. Otherwise, let them file counter.
No, permit us
Yes,
to.
sir, come. Having regard to the submission made by respective parties, without going to merits of the case, writ petition disposed of, directing the petitioner to make a, directing the employee is still alive, medical invalid, yes.
Medical invalid.
Directing the petitioner and his father to make a fresh representation. Father has to make representation. Father of the petitioner. Directing the he is not party here. To make a representation to the respondent to redress his grievance. On receipt of such representation, the respondents make an application as per rules. As per on receipt of such application, the response are directed to consider the same and pass appropriate orders strictly in accordance with the law, as expeditiously as possible. Make a representation within a period of 2 weeks. We are granting time to. On receipt of such representation, the response are directed to consider the same and pass appropriate orders strictly in accordance with the law, as expeditiously as possible, preferably within a period of 6 weeks.
Obliged.
Yes, application. Yeah, we said, Amma, I didn't know. 3 years already payable in both cases. Yes. Respond counts. Yes. Yes.
May I permit your lordship? My lord, the writ petition is filed for that, my lord, not allowing the petitioner into the before the medical board, my lord, SCL medical board. We have filed the application through proper channel. The page number is 58, my lord. In 2021, we made a application and still we are continuing the representation as well to follow up the case, my lord. The page number 58 could see the once, my lord. Page number 58.
Yes.
Being as a petitioner, my lord, the eligibility criteria we met for that 2 years before that, my lord. When I am servicing 4 years of service with SCL, I made a application to be submitted by the employee for arranging medical examination by the corporate medical board, my lord. The dated, my lord, 23/03/2021. My lord, further continuation, I have given the representations, my lord, page number 65 and page number 68 and 70. We have been giving the representations, my lord, but not considered it, my lord.
Yes.
And being there, we
Where do you get that? Yes.
Last he was examined with main of the October 19 2023 and found people using glasses for surface and under referred to higher for attention of the colonial specialist by later dated 2022. We are ready to provide your.
What happened at higher center? Where is that order? Yes, Ravi, page
my lord,
82.
if we could see the page number 78, my lord, there admittedly chief medical officer stating that disability percentage is there. My lord, he's 78 is about, my lord. He was
What do you say about this page 82 letter?
My lord, I'm coming to the point, my lord.
Yes.
Yes, my lord, we are. This is the opinionated by the chief medical officer stating that glasses for eyes, my lord.
Who is competent chief medical officer? Is
My lord, this is for SCCL. The problem is that, my lord, to attention of this court, my lord, they will ask the my lord, company will ask that other party, third party, private hospital to examine only lab test reports, but opinionated by their own doctors. That is the here, my lord, there is a chance of discrepancy here. Further, my lord, this is about the eye issues, my lord. Further, page 78 stating that ear problem. He had, my lord, problem with eyes and ears. How can he go for the duty, my lord? Since last 2.5 years, he is not going to the field. They are stating that we are not allowing to low level and we are giving to surface, that too subject to condition of 3 months. Now they are not allowing to the petitioner to corporate medical board.
Yes.
They are stating 29% is a disability, my lord.
Where is your representation?
My lord. Page number 65 and my lord, and 68, 70. 3 representation has been made out, my lord. Even my application is, my lord, 58, page number 58.
58.
It is a fair case, my lord. Even my petitioner, my lord, I'm even before this honorable court, my lord, we have filed the photos of the petitions as well, my lord.
No, we will direct the respondents to consider your representation.
My lord.
Dated 19/3/2024.
My lord,
latest one.
Within 4 weeks, my lord, can be. Within 4 weeks can be. They can allow to the same, my lord. After, my lord, Diwali, they are trying to conduct a medical board. If they...
Yes, will dispose of writ petitions.
My lord.
Having regard to submission made by respective parties without going to merits of the case, writ petition is disposed of, directing the respondents to consider the representation of the petitioner dated 19/3/2024 on pass appropriate orders strictly in accordance with law, as expeditiously as possible, preferably within a period of 6 weeks.
My lord, another representation also, 16/2/2023. My lord, please record the same.
Okay, సరిపోదా ఎన్ని representations? ఇక్కడ సరిపోతుంది. Yes.
Mobile lordship.
May I please, my lord?
Yes.
The petitioners before lordship, my lord, BTech degree holders, my lord. Not the respondents, my lord, issued, my lord, 2 notifications. One is for the internal candidates, another is, my lord, direct recruiters, my lord. Not they have appointed the direct recruiters, my lord, on 6/6/2016, whereas the internal candidates, my lord, they have not considered. And also on the ground that, my lord, some of them, my lord, approached this honorable court as the, my lord, they obtained certificates, distance education mode, my lord. Thereafter, my lord, they issued another.
Sir, you are seeking notional promotion.
Yes, my lord, appointment also, my lord. Since 6/6/2016, my lord, similarly situated.
Where is your
persons,
representation?
Yes, my lord. Page number, my lord. Page number 33 onwards. And also 29, it is a old one. 17 also we are giving representation. So 33 page number, my lord. 33 and also 36, And also, my lord, the number of representations they are giving 40 also, my lord.
40.
Yes, ma'am.
Then we will direct them to consider your 13, page
Yeah.
40 representation.
Yes, my lord. 36 also we have given.
36, request for implementation of uniform promotion policy. Where is your signature? Who has submitted this?
The petitioners, my lord, all this, my lord. Page number 35, they are there.
Innamul Haq.
First petitioner. my
Innamul
lord.
Haq is part.
First petitioner.
First petitioner.
Yes, my lord.
Where is second, third, and fourth?
My lord, all the petitioners, my lord, this is, my lord, page number 36, my lord, the number of signatures.
36 is signed by batch.
Yes, my lord, batch.
Batch candidates. 16, 3, 13 candidates.
Yes, my lord.
Where is your representation?
Yes, my lord, 39 is the first petitioner, and also, my lord, 2017 representation also is there, my lord. 2017 also, my lord.
Make a fresh representation.
Yes, my lord.
Which order copy? Page number?
Page number not 29, 42. 42 and also, my lord.
Petition having regard to submission made by respective parties without going to merits of the case. Petition disposed of, directing the petitioner to make a fresh representation to address his grievance, duly enclosing the order copy of this court in WP number 42271 of 2017, dated 13th December 2017.
Yes.
13th December 2017. On receipt of such representation, the response are directed to consider the same and pass appropriate orders strictly in accordance with law. In terms of this order?
Yes, ma'am.
In terms of the orders of this court in WP number 42271 of 2017, dated 13/12/2017. As expeditiously as possible, preferably within a period of 2 weeks even work. This is 6 weeks.
Yes. Copy of the order 1 week.
Yes, sir.
Copy of the order. Oblige.
Item 69.
Copy in week, 1 week. Yes.
Please, my lord. I beg to represent, my lord.
Yes.
The petitioner is a senior, my lord. Her junior was promoted as assistant director without reference to charge memo, my lord. Both are facing disciplinary proceedings, my lord. Petitioner and the junior, my lord. In respect of her junior, my lord, she has approached in advance and obtained orders from this court directing that.
Let them file counter.
My case may also be considered on the same lines, my lord. In the review of the deficiency, not now. In the review of
No. Where is R4 promotion shows?
So, I have filed, my lord. Your lordship may kindly see at
Page number?
Page number 16, my lord. Petitions at page number, serial number 3, my lord.
Have you filed this order? 150197 order?
150?
Page 16.
Your lordship order.
Where is that order? Have you filed?
Yes, my lord. I have filed, my lord. Your lordship order is at page number 58, my lord.
So that is also filed by Sudha Jyoti only.
I am representing her, my lord. I am representing her. I am appearing on behalf of her, Sudha Jyoti. Page number 58, my lord. Last 59, my lord, operative portion. Having regard to so and so.
Where is the charge memo? Show us the charge memo in this case.
Charge memo is, my lord, at page 23 onwards, my lord. There are 11 charges against the petitioner, my lord.
11 charges?
Yes, my lord. But, my lord, the charges, all charges are based on one document only, my lord. For the last 4 years, my lord, the inquiry has not been completed.
Read the charge.
Charges are...
First charge.
Her senior student did not produce
1
the
minute,
records,
1 minute.
Without producing the records, my lord, how they can impute charges, I cannot understand.
What is the stage of inquiry? What is the stage of inquiry?
Inquiry officer conducted inquiry, there is no inquiry report, there is no output. No further progress. For that purpose,
Yes, what are your instructions? It is coming for instructions, madam.
3 times, my lord.
Thrice it was urgent.
Thrice it was urgent. Interim order is innocuous, my lord. If she is in the zone of concern, she may be considered in the review DPC. Otherwise, she will not be considered. In accordance with the rules, they may consider. Review DPC, my lord, in the existing or future vacancies, not now.
2020 charge memo.
Yes, my lord. The DPC is held in August 31st, my lord. 24.
Notice. There, 2017 charge memo, we are directed to consider.
This is 2020, my lord.
Please wait. Notice for admission. GP Services 3 takes notice and seeks time to file counter post after 8 weeks. We'll see.
Some date may be 4
Yes.
weeks, my lord. 4 weeks. Some date may be given.
Yes.
Otherwise, he may be retired
19.
without any promotion.
1911.
Much
Yes.
This is a case, again, is the presidential order. The person who is working in the head office has been posted as CDPO as well as the assistant director, ignoring the candidature of the seniors. Her name not even included in the senior.
You are appealing for unofficial respondent. No, petitioners are 9 in number. Why you made this?
She is the person appointed in the head office as a junior assistant through direct recruitment public service commission and promoted as senior assistant in the head office. The head office people cannot be drafted. There is a watertight compartment as per
All
the
nine
presidential
people are working in head office only.
in multi-zone. We are working in multi-zone 2 as CDPOs.
Yes.
We were appointed 2009 to 2013 between as CDPOs. The unofficial respondent who is head office employee cannot be drafted to work or anywhere, cannot be transferred or promoted to multi-zonal posts or zonal posts.
So
They
how
are
you
not
are
entitled.
how you are agree?
She's according to them 2017 she promoted as CDPO. We are 2013 candidate. Ignoring our candidature again is the vacancy of multi-zone 2. She was promoted. We are 2009 to 2013 CDPOs. We are entitled. We are next in the seniority list. She is not even 2013 person. The last person is 2013 of the petitioners.
He is not challenging my promotion as in 2017.
Even AD, that is not.
As per the seniority, now the post of assistant director is categorized as multi-zonal post. So watch me kindly see my promotion order.
No, show us the impugned order here.
Impugned order, GO.
1 minute, Ramesh.
Page 66, GOMS number 7.
No, 119. GORT number 119.
GORT number 119 is the proposals of the DPC. 119 is this is a proposal. GOMS number 7. 2 candidates who are working in the head office.
Yes.
Has been shown
not
against
challenging this one.
GOMS number 7.
Show us 119.
Yes, 68 million. Serial number 1 V Jyoti.
Yes.
HOD they shown.
Yes.
There is no post at all. It is a multi-zone 2 post drafted to work in the head office. There is no sanctioned cadre strength in the head office. The persons who are working.
You are challenging Jyoti's promotion.
Jyoti's promotion because Lordship may kindly consider it is against the presidential order.
Let them file counterability.
May make one submission if Lordship so pleases. Senior at least Lordship may kindly see.
That we'll consider.
This aspect has to be considered. If I'll leave it to Lordships, then kindly consider the senior list which is said to have been published by them, communicated through mail to us, page 71. This was communicated to us on 26th September 2024.
Notice for admission. GP services to take.
It is coming up for their instructions. The Lordship may kindly consider.
You are challenging
the rule itself. Lordship may kindly say the rule struck down.
Let him file.
Rule struck down by the honorable tribunal that is become final, where the channel is provided. Kindly see the tribunal order for a moment. Rule and tribunal order for a moment.
Let him file counter. Notice for admission, GP services 2 takes notice and 6 time to file counter. Mr. Ramesh takes notice for R5 and 6 time to file counter. Post on 18/11.
May I make one submission? Once rule is struck down by the Honorable
18/11.
APAT,
Yes, yes.
Lordships have kindly considered to, peruse the earlier occasion about the Honorable Tribunal's order, which was become final. Under teeth of the order, there is no rule providing a channel to them. Directorate people, which is providing promotion to the post of CDPO, which is an honest in
We
the
decided
IF
on
law.
that day. Anyhow, you are not direct beneficiary.
I am the direct beneficiary.
Nine candidates are there.
First petitioner, Lordship may kindly consider.
With 18/11.
To satisfy that,
18/11
Lordship
we
kindly consider for a minute.
18/11.
I am the next seniority list. I am next person in the seniority list.
I means 9 members.
No, first petitioner.
We'll see.
First petitioner.
18/11.
First petitioner, Millard. This cannot be. My humble submission. This
What
cannot
cannot
be. This cannot be allowed, Millard. Again is the presidential order. Again is the Honorable Tribunal law laid down by.
Yes, next.
This cannot be. That is
Next,
my
next.
submission. That may not be taken place in the department. Otherwise, I won't insist. And the urgent motion list, if Lordships will. Lordships may kindly consider in the urgent motion list.
No, we'll see on that day. Make a mention on that day, we'll consider. Yes. Yes, Srikanth Hariharan.
Petitioner Council, Lordship. It is coming for the extension of interim order, Lordship. They did not file any counter, Lordship.
Who is approved for response in this? Yes. Yes. He is reinstated. He is not reinstated. Workman is not reinstated in all 3 cases. Yes, at request of the respondents to file counter post after 8 weeks. Then we will make it absolute interim order. Why unnecessary? 23 onwards it is being at 8 weeks. Till then interim order shall stand extended.
Sorry. We are sorry for the interruption. Yes. We were at page
171.
Yes.
GMS number 55, I was reading with regard to how they have preliminary examination, admission to the main examination, I was reading. 171B. The number of candidates to be admitted in the written main examination, conventional type would be 50 times. In fact, this, as a matter of fact, GMS 55 was also challenged before this honorable court in a writ petition. Writ petition bearing number 20, bearing number 3048 of 2023.
Kindly repeat the number 30.
Writ petition number 3048 of 2023. State has defended saying that this is GMS 55 is the correct. In fact, the method which is following in other states, GMS number 570 is not correct. It is not appropriate for Telangana state. under para 34 of the council. Well, now, having said so, the writ petition is pending. Just before this notification, they issued page 178. By deleting, that calling category-wise reservation for the main admission, page 178 bottom.
Yes.
B, the number of candidates to be admitted in the written main examination convention would be 50 times to the total vacancies available in each multi-zone. That is also not followed, in fact, 192 page. This is the second sentence, provided that in case of shortfall respect of candidates in reserved categories, laid down in Rule 22, 22A of Telangana State Subordinate, action shall be taken to include such a number of candidates on the merit list beyond 1:50 ratio as required, meet the shortfall. I'll read for this, subject to reputation, Your Lordship permit me to. Number of candidates to be admitted in the written examination would be 50 times the total number of vacancies available. Here, that reservation to be called category-wise, community-wise, has taken up. Now they are just calling, the very total of the preliminary examination, 30,000 they've called it. I already brought Your Lordship notice page 192, 194, 30,000 and odd. 1:50 on the merit basis they call it. They called it for admission, to write examination from October 21st onwards. Giving by reservation at all. Now, the contention is that whether the reservation at the preliminary stage, main stage to be followed or not, what is the law on the subject? According to me, this I'm telling the amending is totally, first I submitted this is without any object, without anything. This is arbitrary, violative article 14 and 16 of the Constitution of India. Second is that the principle of law, right from Indra Sani and Balaji is that, if the vertical and the Your Lordship knows the scheme of the examination. First they take, the open, then, the category wise they go. Communal, then after, like that. Now by which what the principle of Indra Sani is that, the vertical and horizontal reservations are followed. Open and for the reservation categories, category wise, that will serve the public purpose of employment to all.
Yes.
That is the principle of the Indra Sani and other cases. And in fact, Your Lordship put it in one of the judgments while in Madhya Pradesh, saying that the object of implementing of that judgment is to, there is a purpose.
Have you checked whether that judgment was put to test before Supreme Court?
Yes, the Supreme Court has upheld it. I'll just take Your Lordship page. Your Lordship will just come to the page, Supreme Court judgment.
The judgment of Madhya Pradesh.
I'll read out judgment, Supreme Court judgment at page
the
278.
The judgment of Madhya Pradesh High Court.
Yes, not Madhya Pradesh. Your Lordship is not
Your
that.
Lordship's
Subsequently, what happened, as per Your Lordship direction, again examination was conducted. Again it was challenged. When matter went to the Supreme Court, the Supreme Court said, two paras, Your Lordship will just kindly take up at page 478. Well, before that, subject to Your Lordship permission, I'll take up Your Lordship para, one or two paras, then I'll take up the Supreme Court so that Your Lordship have a recollection of
page number
470, Your Lordship judgment running, it started from 390 onwards. I'll take those two paras, then go to the Supreme Court. Page 470,
Yes.
Your Lordship judgment. Ratio decision of Indra Sani is followed in R.K. Sabharwal State of Punjab 1995 to SEC 745. Recently, Saurav Yadav so and so. I would conclude by saying that reservations, both vertical, horizontal method, ensuring the representation in public service. This is the ratio of all the judgments. This is the principle called out. These are all not the same registrars for various candidates in the merit which otherwise entitled for to be shown in the open general category. Foreclosed consequences would be if state government argument is accepted. Doing so would result in communal reservation where each social, this is a principle, where each social category is confined within the extent of the reservation, thus negating the open category is open to all. The only condition for the candidate to be shown in the merit is regardless of whether reservation or the benefit. Finally, Your Lordship, come to page 45. Para 45, 475. The similar position is, the respondents could not assign any justifiable reason to establish rational purpose for bringing the impugned amendment dated 17/2/2020. Similarly, they could not establish the nexus between the object sought to be achieved and impugned amendments. Thus, impugned amendments dated 17/2/20 cannot be given stamp of approval since it runs contrary to the binding precedent of Indira Sahni followed by Saurabh Yadav. The improved judgment cannot be sustained judicial scrutiny by no imagination with standing of the 9 years of Supreme Court so and so. It was open to the government to amend the examination rules contrary to the principles laid down in Indira Sahni under the guard of so and so. Division bench of this court so and so. We are of the considered view. This is the Miller, Your Lordship, that principle laid down in the Supreme Court can be translated into reality only when reserved category candidate should be equal or more marks with the UR category candidate given birth in UR category in all stages of selection. This is an important sentence. Category in all stages of selection, including preliminary and main examination. This is the principle. And the other interpretation will defeat very purpose and the constitutional scheme flowing from the Article 14 and 16 of the Constitution of India. There is no justifiable reason for depriving meritorious. This is another facet of that argument. Meritorious reserved candidates who competed with the UR category candidates secured same or more marks than in being treated as UR candidate. The matter may be examined for other things. Your Lordship struck down that Rule 4.3d of the Madhya Pradesh rules. Then the Supreme Court, Your Lordship, may come to very same batch. After Your Lordship direction, examination was held. Then they challenged. Then it was dismissed when matter went to Supreme Court. Supreme Court upheld 478, come to 492.
No, this is arising out of this judgment or some other judgment?
Some other judgment, but same examination, same rules.
No.
After Your Lordship judgment, they followed the state of Madhya Pradesh. Then there was a challenge again.
Yes.
The same rule, Your Lordship will get it, page 492, bottom para 30.
Which para is relevant?
It was a batch. From the batch, one of the matters went up in appeal, and this judgment is against that.
Therefore, we are asking whether this is arising out of same judgment. Or
Yes. Same judgment.
Your Lordship, see, what are the principles, same rules? Page 30, para 30, Your Lordship. Page 490.
Page 490.
492.
Yes.
We may also note that Rule 4.3d, which Your Lordship struck down. Rule 225 patently harmed the interests of reservation candidates, as even meritorious candidates from such a categories who had not availed any reservation benefit. Relaxations were to be treated along with those reservations and categories, and they were not segregated. This is the Miller principle. Segregated with the meritorious unreserved category of candidates at the preliminary examination result stage. As a result, continue to occupy reservation category slots which would have been otherwise gone in deserving reservation candidates lower down in the merit list, that category. Had they been included with the meritorious unreserved candidates on the strength of their marks. Then, para 31, they have referred to Saurabh Yadav, after the principle of the candidates belong to any of the vertical reservation categories would be entitled to select an open category. And if such a candidates belonging to the reservation category admitted entitled to select on the basis of their own merit, selection cannot be counted against the quota reserved for the categories of vertical reservation. That they belong to it was further observed that both vertical and horizontal methods are ensuring a representation to this is public services, and these are not seen as rigid slots, where a candidate merit which are not being seen rigid slots, otherwise entitled him to be shown as an open category, is foreclosed. Bench further observed that open category is open to all, and only condition for the candidate is to be shown in its merit, regardless of whether reservation benefit or either type was available to him. This is more important. That this is being the settled position. It appears that the state of Madhya Pradesh itself realized the harm that is doing to the reservation category candidates and choose to restore Rule 4 as it stood earlier, which enabled the drawing of the list, preliminary examination. This is the method. Segregating the reserved meritorious reservation candidates with the meritorious unreserved candidates at the preliminary examination stage itself. As this process was undertaken after the judgment of Kishore Chaudhary, that's Your Lordship judgment.
Kishore Chaudhary is the judgment which is authored by me.
Yes,
Now, kindly come to para 33. Kishore Chaudhary was not put to test.
Not subject to challenge before this court. That's what I said.
Kishore Chaudhary is
not challenged.
That is incorrect.
Reference have said so.
It was not put to test.
It was not put to
From
test.
the batch of cases, one matter came up for test.
No, Kishore Chaudhary is the entire batch.
Yes.
That batch did not come. But based on that, another judgment was delivered, which came up for
That is another judgment.
Another judgment. But But another judgment, but Your Lordship, Kishore Chandra Chaudhary case principle has been accepted by the Supreme Court. And the Supreme Court has said, my lord, it is to be segregated at this stage, approved by the Supreme Court. Now, my lord, what's happening is that, my lord, Your Lordship, 1 to 30,000 people have been called. 30,000 reserved candidates are not being called. And what the proviso says, Your Lordship, just kindly come to me, Lord. Proviso says, my lord, if 30,000 if they called, if reserved candidates are not there, they will apply the proviso. By which they call again 1:50%. That's what the proviso says. Instead of right royal method, whereby we not open category, we not in this case, about 206.7.
What is the material today before us that the petitioners who are reserve category candidates secured more marks in preliminary examination than the general category candidates, and yet you have not been selected? What is the material before us?
No, one of the candidates.
Principle we have laid down, we are aware of it.
Yes.
But what is the factual basis for that?
In fact, the one of petitioner number 4 is successful candidate. Well, the question is that, what's happening?
Can you show any example that a reserve category candidate secured more marks than a general category candidate, still could not secure berth?
At this stage, results, marks are not being announced, I cannot demonstrate.
Then this argument,
but Your Lordship, I kindly see, Lord.
Then this argument is premature, because unless you are in a position to show the breach of the principles laid down by us.
I'm come to that. Well, I'm saying that by calling 1:30,000 on the merits how they called. What they said, Your Lordship, is just take the counter so that it will be clear, Your Lordship. Right? Your Lordship, I kindly see. Just take them, their counter, they file the counter. How they want to follow.
Who filed counter? State filed counter.
Public Service Commission is
we filed counter.
State
has not filed counter.
State, I represented, my lord, in the first instance itself.
But you have filed or not counter?
No, my lord, state has. It is the PSC counters, my lord, which got returned for some reason.
When PSC filed counter?
Yes, we have filed.
Lord, this is an objection which I took at the last occasion also, my lord. They have challenged the wires of the rules only to bring challenge of 29 before your lordships, my lord. GOMS number 29 are already challenged before a learned single judge. Counters are filed, they are being argued there. Now, my lord, they are re-agitating a GOMS number 29 before your lordships under the guise of that challenge to wires of Disabilities Act. Lord, they are to agitate on the rule.
I'll come to that. I'll come to that.
We'll hear you. Without hearing you, we will not pass order.
Your Lordship, I kindly see para 50 of your council.
Yes.
Para 15. It is humbly submitted that procedure for shortlisting of candidates from the preliminary main group examination service. Your Lordship, I come to next page 10. Elaborated in GMS number 29, maintain right of so and so balance for need for representation of each community category by adopting the following procedure. 1. Initially, the candidates are shortlisted at the ratio of 1:50, meeting the general standards level based on the overall merit. The candidates of all the communities, OCs, SC, SCs, are all in the list as per the merit. First, they admit entire on the basis of the merit list. Second, they say Roman 2. Among the list of candidates shortlisted, it is checked whether the candidates from they will after that list 30,000 they call it. They say among the list by following GMS number 29, among the list candidates shortlisted, it checked whether the candidates from each category is also are represented in the ratio of 1:50. They do that thereafter, saying that they will check up themselves whether or not the reserved candidates have come up or not up to 1:50%, which is to be called. Then they go. Well, that is putting the cart before the horse.
One thing is that both the instructions, GOs, which are under challenge before us, are not issued under provision to Article 309.
One is under Article 309.
Which one is under 309?
Well, that is Rule 22B.
Which one is 309?
96.
Which GOMS is 309?
96, page 96, 152.
This must not be under challenge before single bench.
Lord, this is the rules, my lord. This is not. This is not before the. Yes, my lord. This is not before the learned single judge.
If they have challenged it, it will come before this bench only.
Yes. My humble submission was, my lord, that under the guise of challenge of these rules, my lord, they brought in 29 also, which was subject there. My lord, it was never their intention to challenge the Disabilities Act, is my understanding, because the lordships have seen
the candidates whether their challenge to this page 152 will fail or not, we will decide at appropriate stage. But till such time, the roster is with this bench only.
Yes.
So far other matters are concerned, you may file an application either before Honorable Chief Justice or before that bench for transferring this matter, because other things are also under challenge for linking those matters.
True, my lord, on last occasion.
But this can't go to single bench.
No.
Yes.
To the extent of rule challenge, my lord, it is before your lordships, my lord. There is no dispute. On last occasion, my lord, 4 writ petitioners who filed, they are not belonging to disabilities category, but they challenge the Disabilities Act.
You see, this is all your anticipation on the basis of...
Not anticipation.
Just a minute.
I'll demonstrate.
Please allow me to complete my sentence, Mr. Counsel.
Yes.
This is a stand taken by PSC. On the basis of that stand, you are making a submission. But there is no material available on record which shows that any meritorious reserve candidate secured more marks than general has secured berth and at the cost of his merit. This is, as per this PSC.
They have not disclosed. They are not disclosed. They are not giving the merits.
This will remain subject to, yes, that selection will remain subject to final outcome. But at present, very question.
The reason for that is...
Let me complete. I'll demonstrate one.
One reason why we are not able to answer your lordships in affirmative is that marks are not given, and our contention is going to be if the process by which you are doing it suffers an illegality. The material fact as to whether I fell within that category or not at a later point in time would be immaterial when your lordships are judicially scrutinizing it. Your lordships are looking at it from the angle as to whether the decision-making process is constitutional or not. If we are able to show your lordship that the decision-making process is vitiated by constitutional tests, then the whole process will have to go. Therefore, to test it at this stage, on the ground that whether the petitioners are sufferers or not would be
immaterial.
One. And the second aspect is your lordship may kindly see. Suppose I am a person who gets these marks and come to your lordships. Then the reverse theory will be put on to me saying, you appeared in the test, because you have not got marks, you've come here, having participated, you can't test it. So both ways I would suffer, and that is why we are at the right time before this honorable court is our contention.
Yes.
As far as the petitioners are concerned, 3 petitioners are SC, ST, BC, petitioner 1 to 3. 4th petitioner is BC category. He, in fact, got into the main examination. When I just reading other 2 clauses, your lordship may kindly see that, my lord. First again, my lord, candidate shortlisted 1:50, including generals, based on the overall merits. Page 10, my lord, para 15.
Yes.
Candidates are shortlisted at the ratio of 1:50, meeting the general standard levels based on the overall merit. The candidates of all the communities, OCs, STs, so and so, are all in the list as per the merit. Next, your lordship, among the listed candidates shortlisted, means open category. Your lordship may just kindly see. Open category. It is checked whether the candidates from each category, reserved category, also represented in the ratio of 1:50. May not 1:50 may not have reserved candidates may not as per the category wise entitled to be admitted in the main examination as per the notification. Because 1:50, your lordship reservation, whatever the category they fixed. I'll just page 67 of my paper book, your lordship will know what are the reserved categories they have given along with the notification. Now they are not, community wise they have not called, open they called. What they are saying is under 2, 1:50 only will be maintained in respect of the reserved categories. Whereas open category candidates are getting number of more than that. More than that. Your lordship, on page 67 of my paper book, your lordship may just kindly take up, my lord. My lord, the categories, my lord, like this will be filled up.
Yes.
Page 67, the bottom, your lordship may come to. Total vacancies. 209 for OCs.
563?
Yes, my lord. Total out of 563.
Yes.
209 for OC. 49 EWS. BCA 44. 37 BCB. BCC 13. 22. 16. 93. Then, my lord, physical camp 13, 8, so and so, total 563 talent. juxtapose, that, this into, Roman 2 of the para 15.
Yes.
What they say, they call open under the first Roman I, overall merit basis. Then they go Roman 2. Roman 2. Principle of segregation, Supreme Court said. If the meritorious reserve candidate, suppose he gets open, the balance of list categorization will go to the below the down the line. That's what the Supreme Court said in para 30. Now what they do is that they just calling open, that thereby what happens, open candidates are getting an advantage of more than what they had it been open this thing 209 inclusive of SC, BC meritorious candidates, it would have been included only 10,000 and odd. Whereas now 30,000 on the merit being called. Now these categories are not there. According to them, these categories are not there. Therefore, what they do is that 28,180 or 280, 1:50 ratio, they call 31,000. Thereby, if a category was called, what happens when, for example, BCA, your worship will take it up. 44 people are not available in that 30 slot. What they are saying, they will only restrict to 1:50 under Roman 2.
Yes.
Thereby, more number of candidates from the BCB category, BCA category, are not coming to them for admission. And more open people are coming taking advantage of that examination. Thereby, the arbitrariness lies. And not only arbitrariness lies, the principle of the Supreme Court is that if the vertical, Lordship knows reservations, how they follow. First is open category, then the social reservation they follow. If the vertical reservations, horizontal reservations, suppose followed same manner, we will get more number of candidates will come appear for examination. For example, British 1 to 3. Maybe they were in 31,000 position. Because of this, they are not getting into that. Had a category wise they called, we would have been there. Because of not calling category wise, we are being deprived of consideration, which is the right under Article 16 is being deprived.
That you have already
By this method, arbitrariness.
That's all. Anything else? Yes. That's all. Otherwise, we'll hear the.
This is the principle that as far as that is concerned, I have already. Deependra Yadav case, your Lordship case, I got it, segregation principle, and every stage it is to be followed. Para 45 of the your Lordship judgment. As for the two judgments with regard to my Lord, in fact, one thing is I want to bring it to your Lordship note. GMS of 55 they challenged. Your Lordship and company, they filed a counter. 215, page 215. GMS 55 was challenged in the writ petition number 3048. It starts at 199.
250.
215.
This is a counter file in other case.
Other case where GMS number 55 challenged.
Which is before single bench.
Single bench.
So the Learned Government Council is talking about this one.
No, not this petition. He is talking. Why I am saying that
Yes.
It is submitted that the existing rules provide that the existing rules reservation laid down under Rule 22E. Telangana State Subordinate Service roster points earmarked in the 100-point cycle PH are 6, 1, 6, 31, 56 and 82 allocated from open category. This is totally wrong. They also reiterate the same thing in the para 37. Well, straight away, I'll place your worship the Supreme Court judgment, which Rajesh Kumar Dairia and another page 270, same paper, my paper book, your worship, I come.
276.
270. Paper book. Para 5 minutes, only one paragraph.
276.
271 minutes.
Sorry. Yes.
Before examining whether reservation provision relating to women has been correctly followed, it will be under so and so refer to horizontal nature of horizontal reservation in the manner its
Sorry,
application.
you are reading from which paragraph?
271 para 5 minutes.
5. We'll request you to read it again.
Right.
Yes.
Before examining whether reservation provision relating to women and has been correctly applied, it will be advantageous to refer to the nature of horizontal reservation and the manner in its application in the Rasani so and so. The principle of horizontal reservation has been explained thus, para 8112. All reservations are not the same nature. There are two types of reservations, which may, for the sake of convenience, be referred as the vertical reservations and horizontal reservation. Reservation in favor of scheduled caste and scheduled tribes and other backward classes under Article 16.4 may be called as a vertical reservation, whereas the reservations in favor of the physically handicapped, clause 1 of the Article 16, can be referred as a horizontal. The horizontal reservation cut across the vertical reservations. What is called as the interlocking reservation. To be more precise, suppose 3% of the vacancies are reserved in favor of the physically handicapped person. This would be a reservation relatable to clause 1 of the Article 16. The person selected subject to quota will be placed in the quota by making necessary adjustment. Similarly, if he belongs to open competition category, he will be placed in that category by making necessary adjustment. Even after providing these horizontal reservations, the percentage of reservation in favor of the backward classes citizens remains and should be saved. A special provision, this is the special provision for more so in respect of the employment is under special constituted as social reservation under Article 4. The method of implementing social reservation is horizontal, cutting across the vertical reservations as explained in the Anil Kumar Gupta versus State of so and so. The proper and correct course is to first fill up. This is the course. The proper and correct course is to first fill up the open candidate quota 50% basis merit. Then fill up social reservation quotas. Then SC, ST, visa. Third step would be to find out how many candidates belong to the special reservations have been selected on the basis. If the quota fixed for horizontal reservation is already satisfied, for example, 3 posts are there, not. If they come on the 3 posts in the physical merit, question of again further going down will not arise. If the quota is fixed for the horizontal reservation already satisfied, in case it's the overall horizontal reservation, no further question arises. But if it is not so satisfied, the requisite number of social reservation candidates shall have to be adjusted, accommodated against their respective, again, social reservation categories by deleting the corresponding number of candidates therefrom. However, it is a case of compartmentalized horizontal reservation, then the process of verification, adjust, accommodation, as stated above, should be applied separately to each vertical reservation. In such a case, reservation of 15% in favor of the social special categories is applied. Now, Your Lordship, see the counter. What they are saying, they are taking open category. That is
already pointed out.
Yes, that's it. Well, in fact, the one judgment of the single judge, but saying that roster points also illegal. Your Lordship, just kindly come to page 292.
292.
292.
292. It begins from?
It begins from, the 270.
275.
275. Come to below 292, para 53.
It's Andhra Pradesh judgment.
Yes. As my submission, below is not binding on your lordship. As my submission,
No,
your
no.
lordship. Yes.
So it always have a persuasive value.
Yeah, persuasive value. That's all.
Yes.
The purpose of horizontal reservation to ensure a minimum number of persons from the category. This is the, it's not open category giving me not now percentage 54 making. Purpose of horizontal reservation to ensure that minimum number of persons from the category are able to get post. Horizontal reservation cannot be implemented by reserving roster points and again permitting the persons of category to participate in the recruitment process. Well, GMS number 196, page 152, Milord, 22 BE. Milord, I am challenging this. To participate in this, such a method is anathema to the horizontal reservation that would effectively place vertical reservations and horizontal reservations on the same footing. In such a case, protection given to the horizontal reservation in Indira Sahani case would be not be available to protect such a reservation when the cumulative reservations cross the 50%. Here, if that 4% is taken, it's amounting to now, in fact, 58 here. No roster points can be fixed in the case of horizontal reservation. This is another. Even otherwise, no roster points can be fixed in case of horizontal reservation, as the said system of reservation operates on a different principle.
Yes.
There is also same 4% that was struck down. I need not trouble, that's already Rajendra Kumar, this thing is principle followed in 1995 Supreme Court 173. Para 18, you should note that the procedure how to follow has been given. Para 18, yes. Same principle which is Rajesh Kumar Daira, they have referred to those. To sum up, my submission is that, amending GOMS number 29, as for the physically handicapped, I brought, no, there can't be no roster points, there can't be any vertical reservation, and as far as the coming to the GOMS number 29 is concerned, it violates the principle of participation in Indira Sahani principle. And second, amending GOMS number 55, taking out the reservations, its no purpose will be served. In fact, it's a detrimental. I demonstrated page 67, showing the principle that the particular BC people are not being come. Now, they are taking after that only 1 is to 50%, by which they are being restricted. The procedure,
which is that statutory provision which is under challenge before us.
Come to page 152.
Page number
152. 153.
This is under Article 309.
309.
Yes.
Page 152, your Lordship can read the notification itself. Article 309. Come to page 153. Fixing the roster point. 6, 31 and 56.
Yes.
Since my submission is that since I am challenging the procedure is violation of the law laid down by this honorable courts, including Supreme Court of India, Indira Sahani case and Madhya Pradesh judgment. Therefore, it cannot be said that I cannot challenge it. And also, there cannot be estoppel against law. The principle of Supreme Court is a law, binding on all authorities, including the public systems. Therefore, they are bound to take the note of it, and they must follow category-wise reservation. If the examinations are not straight, my request for the interim order is if examinations are not straight, follow the GMS number 55, call for the persons as per the earlier whatever they have done for notifications, earlier notification, examination be conducted. Thereafter, your Lordship may take call on the main writ petition and do that.
And after the written examination, what is the next step in this?
Next step, interview is not there here, They will announce it.
There is no interview.
There is no interview. They will announce selection.
I'm going to point out that was one of the factors that worked in that earlier judgment. It was a 3-tier selection. I'll come to it when
No, but in GOMS, whether they have reduced from 3-tier to 2-tier.
Yes.
Interview was earlier there, now it is dispensed with.
Yes.
So the GOMS 55 says that there should be an
Even
interview.
55 did not have interviews. Even 55 didn't have.
didn't have that. It is pre-55 era.
Pre-55 era had interview. And the judgment that they are relying on is the pre-55 era judgment.
But I'm only saying the state will come out with in the counter and etc. They'll come out with saying that we have already issued, the hall tickets, etc. and the examination going for 21st. I'm saying that if you also don't want to interdict, stay the process. I've prayed for interim direction, also saying that follow 55, which they have defended in the various forums before this honorable court.
Yes.
By following reservation, you also not put whatever the riders you also want to put it. Will not hear the matter and main, and then that will be instead of Yelaship in Madhya Pradesh, Yelaship in fact set aside the selection, para 47. Again, re-examination was conducted. Instead of that, that course can be adopted. A justice can be granted to the reserve candidates. They are depriving their right for a consideration in this manner arbitrarily.
That's all. If anybody wants to supplement petitioners, this will only request not to repeat. You can supplement.
Unless that we make some submissions, like may overlap also.
Try to be more.
Because blood your lordship knows very well. Blood same thing. Anyhow, blood we have to make our submissions.
The vice of batch matters will suffer a little bit of.
Blood overlapping.
The only request is to be precise.
Yes.
The only request is to be precise on a lighter side.
Yes, that's a virtue KG has.
On the lighter side. On the lighter side, Justice Bachawat used to tell that argue in a capsule manner. We will say that argue in a homeopathy globule manner. Yes, please.
Exactly, blood I will follow you.
Yes, please.
Now, blood, as blood, my learned friend, blood rightly, blood, put it, blood, all the things. Now, blood, your lordship, kindly see. Basically, blood, what is now we are, blood, challenging before your lordship is, blood, GOMS 29. On the ground, blood, the reserved categories are being deprived. Blood, the proper reservation as provided under the Constitution and as held by the Honorable Supreme Court in several cases. That your lordship may kindly see, your lordship knows very well. That as per GOMS number 55, that my learned friend has read in my booklet, that my WP is that 28488 of 2024. 28488 of 2024. It is also there. In the morning, blood, your lordship permitted us to blood move a lunch motion. We have moved it. It is, I think, it is there very much.
Yes.
Blood, I find blood both GOMS 55 and 29. Blood, your lordship may kindly see. Blood, first, your lordship may kindly see. Blood, the background of this public service commission examination conducted by the Telangana state is. Blood, your lordship may kindly see. 2-tier examination only. Blood, then blood, it was initially one notification was issued. Then blood examination was conducted. Thereafter, blood, that examination was blood because of there was again that was the subject matter before the honorable court, and blood there was a leakage of paper. Then blood that was cancelled. Then second examination was conducted. Blood that was also blood this honorable court blood because blood they have not followed blood biometric principle blood, therefore blood it was set aside, and then blood the third notification is only blood your lordship kindly see. By adding 10 vacancies more than what has been earlier notified in both the notifications.
60 were added.
Yes.
60 were added.
60 were added. 60 were it is state where different blood setup, blood conditions are enumerated. The state of so far as state of Telangana is concerned. In other states, blood this position is not there. Therefore, we want to follow 55 alone. Blood following rule of reservation. What it says is blood in preliminary examination, they followed blood 1:50. blood a candidate who secured, blood a reserved candidate who secured blood top marks, blood in the merit marks. That means blood number one meritorious candidate blood in the preliminary examination. He will be considered blood in the blood open category candidate only. Then blood one more blood reserve candidate will get that post blood in the reserve category blood. This aspect blood you may kindly see. This was followed blood first time and second time. When it comes to latest notification blood third time, blood they amended GOMS 55 issued GOMS 29 and they say that blood the any shortfall is there, then only we will consider blood the other candidate if required. Thereby blood you may kindly see. First blood GOMS 55 I will refer to in my repetition blood page number blood you may kindly see 41. Dated 25/4/2022.
Yes.
Blood para
This
5
55 is also under challenge?
55 is not under
Not under challenge. You are
Here,
happy with
other
55?
repetition.
It is under challenge in another repetition lying before the single judge.
But we read
In these batch of petitions, it is not under challenge.
No.
in this
Earlier there was challenge when I read.
So that is upheld.
Page 250.
That is upheld.
This is upheld. You will have to be correct.
So you are happy with
Yes, blood. We are
Not
happy.
upheld, it is pending. It is
We
pending.
are happy with 55.
It is pending. They filed a counter defending 55. That's what I said.
Correct.
Page
We
215.
amended, the writ
It
is
is
pending,
pending.
amendment is.
It is
it is
pending.
pending before single bench.
Single bench, they followed it, blood 55. Even if now blood they followed, one of the prayer we sought in the repetition is, in the present repetition also interim direction, blood as my learned friend said that, let them follow 55, we have no objection. Instead of 29, depriving blood, a more meritorious blood, the person who secured merit mark, blood in the reserved category, is being deprived of, and blood is being shown in the reserved category candidate.
But pausing here for a moment, this exercise, whether GOMS 55 or 29 is to be followed, will be post written examination. While deciding the question of filling the
No, this
vacancies.
is only for preliminary to main examination. This notification only for main, preliminary main.
That's
What
why
they
blood-
said, like Madhya Pradesh 43D, what they said in the main selection, they followed that reservation. What we are saying is that not main selection, please follow in the main, preliminary to main also.
Now, blood, you may kindly see GOMS 55 blood at page 41, blood dated 25/4/2022. Blood para 5, you may kindly see. Blood government of the capable examination of the proposal of the Public Service Commission and keeping in view of the amendment issued in GOMS 11th read above, have decided to issue consolidate orders afresh and incorporating the amendments proposed by the Public Service Commission. Then blood para 5. Accordingly, the government hereby follow the classification of the posts and scheme of examination for various categories of posts to be filled by the direct recruitment through the Telangana State Public Service Commission. Then blood after all these things, page 44 you not pattern of examination. That's blood I only blood read B1, B only blood.
Yes.
That pattern of examination B you not number of candidates to be admitted to the written examination, main examination, conventional type would be 50 times to the total number of vacancies available to each multi-zone, duly following the rule of reservation for community, gender, EWS, PH, and sports, and as laid down in the General Rule 22 and 22A of PS and the State and Subordinate Service Rules. So it clearly classifies not this by following these, what they have done is, even in the preliminary examination, not 1:50, that they followed not this rule and not the meritorious candidates among the reserved candidates have been considered in the open category, merit. Only considered in the merit. Then not rest of the things, not other category, reserved category candidates have been considered. Now, by virtue of not an amendment, blood GOMS 29 is at page number blood 51. blood and the scheme of examination for group 1 services prescribed in the government order first read above, and in the light of certain court cases filed in this regard and observation of the Supreme Court of India in the case of so and so AP Public Service Commission versus in 29. That is the only, let the reason and object that is amending this 55 and issuing GOMS number 20. Let this directly violates Article 14 and 16 of the Constitution of India. Is my submission.
Yes.
Then let
We will continue tomorrow.
Tomorrow, as
we will continue.
As yes.
Okay, Shri, this batch matter, entire batch. Mention the names of the senior counsel and all the counsel for appearing for the parties. Telangana State Public Service Commission, state government. Because of paucity of time, a spread list tomorrow.
attend the Group 1 mains examination scheduled for the October 21st. Despite possessing genuine sports certificates and Form 1, having participated at international level and multinational levels in rolling skating, which is recognized sport under the 74.
No, we will consider, challenge this, we will consider.
Millers, no, I don't have any concerns. Only the point here is 21st is the date of this one.
Challenge this, sir. Unless they are being challenged to the.
Millers, the only concern.
They have already rejected. Challenge it.
No, kindly come to.
What is the difficulty in challenging? Tell us.
Sir.
What is the difficulty in challenging?
21వ తారీఖు exam start.
What is the difficulty in challenging?
It's only time constraint. 21st.
That for you, sir, if you challenges will begin.
ఒక్కసారి మీ ఆర్డర్
Sir, council, they have passed some order. We directed to consider the representation.
అదే మీరు డైరెక్షన్ ఇచ్చింది 2 వారాలలో చేయాలి. 4 వారాలలో నేను రిట్ పిటిషన్ సబ్మిట్ చేసిన తర్వాత చల్లగా చదువు చెప్పినట్టుగా ఈ ఆర్డర్ తీసుకొచ్చేసి దీంట్లో నాకు ఒకటే ప్రశ్న సార్, వాళ్ళు కనుక ఈ ఇంటర్నేషనల్
Sir, we will examine that, find it, challenge it.
wrong. See, my point is only one thing: the wrong order cannot refrain me from praying for this honorable. See, ఎక్కడ ఉందో చూపెట్టమనండి. ఇంటర్నేషనల్ స్పోర్ట్స్ ఫెడరేషన్.
Sir, that is not a subject matter of writ petition. Challenge it. We will consider, challenge it. You know, in August itself, your position.
No.
You know your position in August itself.
After knowing Millards,
August itself.
I submitted. See, my bad part is Millard. I or the old the council.
Ramesh, why you are wasting your energies? Challenge that, we will consider. What is this? Follow the code.
Follow. The only thing is like, no, this cannot sustain. That's a
Challenge it.
No, see.
No, sorry. Yes,
Millard,
next.
for each and everything, I cannot.
Yes,
this one.
that's for you, sir.
Millards,
We won't suggest, we won't advise.
Millards, kindly consider the fact, Millards, each and everything, because of this itself wrong. No, if
Ramesh, what is this?
74 జీవోల వాళ్ళని చూపెట్టమనండి.
Sir, challenge it.
ఈ తప్పులన్నిటిని ఛాలెంజ్ చేసుకుంటుంటే
That's for you, sir. Yes. That is for you, sir. You are the counsel. Take assistance of any senior. What is this? You have to challenge that. How can we interpret that without there being challenge?
When it is not a reasonable order. That
Sorry, Ramesh.
As the order itself.
Sorry.
With your lordship kind permission, item number 127, my lord.
Sir, no mentions in the afternoon. Why?
Tomorrow, because I was waiting, my lord, it may reach.
In the
Okay, it may not be
afternoon,
listed.
where?
No, it may not be continued tomorrow. That is the only difference.
Yes, next week is.
Next week it will become infructuous, my lord. That's
What can we do? 120?
7, my lord. Because it has come up before vacation also, my lord.
Come on, 1. One minute, this is 2024 matter. What is the matter about?
Pertains to the group 1, my lord. They are not following the rule of reservation. G.O. 29 is challenged, is petition, my lord, covered by.
ST reservation. 29, what is the?
29 is the amendment to the rule of reservation has to be followed, my lord. What they are doing, they have to do is, my lord, they have to carry for one post, my lord, it must multiplied by 50. What they are doing is total posts multiplied by 50, irrespective of the leaving apart the reserved category, my lord. That's covered by Supreme Court judgment, my lord, directly on the same point.
No, as an intermediate, what are you seeking? As an intermediate, what are you? As an intermediate, what are you seeking?
To consider the cases of the, my lord, candidates
How
my
many
lord, for
candidates are
eligibility for reserved category candidates, my lord, for appearance for main examination only.
Notice was ordered.
Yes, my lord. Before a vacation, my lord, they have filed their counter also.
Counter is filed?
Yes, counter filed, my lord.
G.O. 29 is also under challenge before division bench. Right now, the matter is going on. It will going to spill over for tomorrow also. Let us wait, my lord.
In fact, my lord, in the said, my lord, before the division bench, the stand taken by the respondent, the matter has to go before the single judge.
That also division bench will decide, my lord. The fact of the matter is 29 is before division bench.
127,
Yes.
Thursday, we'll see.
Very well.
115,
Sir, there is a group one, that is the reason I will.
115 last time, sir. Sir, 115.
All matters will be listed next Tuesday.
Sir, last time, before vacation.